Start. Secondly, it is only one third of the amount that had been paid in advance to the petitioner, and the rest being allegedly disputed has now been deposited in the year 2017 without there being any material to indicate the disposal of the objections by the two real brothers of the petitioner. Full stop. The amount that had been received by the petitioner was at the rate of rupees 10 per square feet. Full stop. This stood enhanced to the tune of rupees 23 per square feet. Full stop. The enhanced compensation was neither paid to the petitioner nor was it deposited in the court concerned. Full stop. Thus, if there is a partial payment to the petitioner and which is not the substantial amount, then in our opinion the ratio of the interim order passed by the Honorable Apex Court in the case of Lucknow Development Authority Supra, quoted here and above, dated 17.4.2017, would not be attracted. Full stop. On the other hand, the judgment in the case of Chandrasekhar Supra, which has been affirmed by the Honorable Supreme Court on 3.4.2017, read with the judgment in the case of Bimlendra Mohan Pratap Mishra Supra, would be applicable, and the acquisition will, therefore, have to lapse in view of the aforesaid conditions existing. Full stop. Para. The question of delay as raised by the learned counsel for the respondents also deserves rejection, inasmuch as the 2013 Act came into force on 1/1/2014. It is in this background that the passing of the award in 2007 cannot be a ground to count laches from 2007. Full stop. To the contrary, the 2013 Act itself provides the leeway period of 5 years prior to the enforcement of the Act as the date of award for applying the provisions of section 24 (2) of the Act. Full stop. In our opinion, there is no inordinate delay as urged on behalf of the respondents, and to the contrary, the deposit has been made on 2.2.2017 after the filing of this writ petition on 23.1.2017. Full stop. Para. In the aforesaid facts and the compensation of the land having been clarified, there is one fact that will finally determine the claim of the petitioner, namely the issue as to whether the petitioner had received his full and final payment to the extent of his share or not, would be dependent on the fact of the extent of his share to which he is entitled to receive, as his brothers are claiming 2/3 of the amount from the entire amount payable. Full stop. This would therefore be required to be determined finally, and therefore this writ petition is disposed of with a direction that this issue relating to the share of the petitioner be determined, if not already disposed of by the competent court in terms of the notice that has been filed by the petitioner along with his rejoinder affidavit. Full stop. The acquisition proceedings will be treated to have lapsed in the event it is found ultimately that the petitioner has received only part of his payment to the extent of his share as noted above. Full stop. This exercise shall be completed within 3 months. Full stop. Over.